The Honourable Chief Justice of the Family Court, Diana Bryant, is delivering the keynote address of Talking Justice 2017. Now, in her address, the Chief Justice will canvass the family law measures announced in the recent federal budget and, more broadly, look at some of the contemporary challenges facing the family law system. Now, following her address, we will hear a short response from three leading family law experts. We have Kylie Beckhouse. She is the Director of the Family Law Practice with Legal Aid New South Wales. We have Melbourne QC, Gerard Holmes, and we also have Monash University academic and barrister, Dr. Renata Alexander. And after that, we're going to have a panel discussion and we'll open up the conversation to your input and to your questions. Now, for our keynote address, Diana Bryant. She has been the Chief Justice of the Family Court of Australia since 2004. She is also co-chair of the Association of International Family Judges. In 2011, she was made an Officer of the Order of Australia for her distinguished service to the judiciary. And throughout her career, she's had a long-standing commitment to the advancement of women in the law, and she's currently the patron of Australian Women Lawyers. Would you please welcome Chief Justice Diana Bryant.
Thanks very much, Damien. And can I say what a pleasure it is to be here this evening in this beautiful building and to give what I'm going to call a somewhat reflective view of family law. First of all, though, may I pay my respects to the traditional custodians of the land, the Jai Wurrung people, and to their elders past and present. I was asked if I would talk about contemporary issues in family law when I was first asked to do this, and my attention was drawn at that time to comments that Pauline Hanson had made about wanting to get rid of family courts and have a tribunal of ordinary Australians. I was going to, I prepared a few weeks ago on the basis that I was going to tell you how I thought having a tribunal was a really bad idea, and then on budget night the government announced they were going to have one. So I've thrown that one away and I've got a different paper. It is a good time to talk about family law given the government's announcements on budget night. And for me, as my tenure as Chief Justice comes to an end later in the year in October, it is, I think, worthy of, for me at least, reflection on the system. I know that those of you who are here, most of you work in family law in one way or another, and you're very familiar with the issues and the day-to-day problems that family law provides for all of us. So I'm going to try and take a bit of an overview about our system, the things that are wrong with it, the shortcomings, and what we might be able to do to improve it. It's pleasing for me, at least, to note that the government is taking an interest in family law, I would say at last, and looking at ways to improve its delivery both in the short and long term. I think this could be, in many ways, a watershed for family law. I've been bemoaning the lack of attention to the delivery of family law by government for some time, particularly in relation to funding the courts. So I do want to record my pleasure that it's now well and truly on the agenda. I will leave in October pleased about that, because I was despairing of whether the government really had any interest in doing anything for the courts. Talking about what the government said on budget night, I want to first discuss the establishment of what is in effect a tribunal by another name, parenting management hearings. I don't use the term tribunal derogatively, but simply as a descriptor. That's what three statutory officers making decisions about contested parenting issues are. I fully understand the constitutional constraints and the desire to avoid them, and to try and make this an administrative tribunal rather than a judicial one. Whether that's possible remains to be seen, but I'll proceed on the basis that it will operate and may survive constitutional challenge, if any. There's been some media about the proposal, but not a lot. Perhaps that's because the detail is scant at this stage. The Daily Telegraph in Sydney had a headline which said, cavalry call for custody clashes, and the article notes the establishment of this initiative is in large part in order to provide a timelier, less expensive opportunity for hearings than presently exists. The courts are presently swamped by matters, as we all know, and it's been a matter of public concern by me in particular, indicating that we're letting parties down by not being able to provide a more timely hearing. And I think anyone who practices in the area knows that that is the current problem. So much is true. And this proposal, which is a pilot and which will be for self-represented parties, has the capacity to provide a better environment for determination of their disputes. As well as providing a faster route to adjudication, it's also an opportunity for a less adversarial, different kind of hearing in parenting matters, where issues between the parties are able to be determined with an inquisitorial hearing, where parties are not represented by lawyers. The aim, it is said, is to utilise a triaging process to work out how the parenting issues could be dealt with most expediently, and wherever possible, averting them from the litigation pathway. There's no doubt that this process is suited to self-represented litigants. The parenting management hearings will be conducted by a panel of 3, which will include a lawyer and a psychologist and/or social scientist, and be assisted by independent children's lawyers attached to the tribunal. Cases will be managed by tribunal staff using questionnaires. No lawyers will be permitted and no cross-examination will be permitted. It's intended that issues will be identified in advance, facts will be established from the questionnaires, and a 2-hour hearing is envisaged. A decision, it is intended, will be handed down almost immediately. But there are many questions that arise, for me at least. The Children's Cases program, piloted by the Family Court in 2004, developed the very features that I anticipate will be seen in this model. Indeed, Professor Patrick Parkinson, who seems to be the author of this plan, in a paper delivered on the 9th of May, referenced the tribunal being modelled on the Children's Cases program, piloted by the Family Court, and later implemented by the Family Court as the less adversarial trial, as well as the informal domestic relations trial in Oregon, United States, which actually of itself was modelled on the Children's Cases program. There are 2 significant differences, however, between the Children's Cases program and the Oregon model, which is called the IDRT. The IDRT was originally piloted in Deschutes County Circuit Court and then recommended for expansion statewide in Oregon. In Deschutes County, the parties were offered a choice. They could proceed using the traditional trial or the IDRT. All matters of property division, support and children's issues could be heard and decided through an IDRT. In the January 2017 issue of Family Law Review, William J. Howe III and Jeffrey Hall wrote, Initially, IDRT was conceived as a process to more efficiently manage the crushing family court docket and also as a way to relieve judges of the discomfort and concern over whether relaxing the rules of evidence or assisting in the preparation of judgments would violate judicial ethics rules. It immediately became obvious that the benefits of IDRT were far greater than judicial economy and avoiding judicial ethics heartburn. This process was greeted by litigants as affording access to justice in a way that self-represented litigants, even more than represented litigants, felt was more understandable. Furthermore, procedural fairness was advanced as litigants felt and experienced being heard directly by the person who possessed the power to resolve the dispute. That's all true, and certainly that was our experience of the Children's Cases program, but I think we have to remember that in large part, perhaps the United States courts were coming from a much more adversarial system than we are. The second and major difference, I think, between what Professor Parkinson was modelling his model on is that the adjudicator remains a judge. The IDR process, and thirdly, the IDR process doesn't limit either party's right to appeal. Unsurprisingly, their evaluation found that the broadest category of cases that were appropriate to the IDRT process were those where neither party was represented, where the marital assets were reasonably straightforward, and where no expert witness testimony was critical to achieving a just result. Not sure how many of our cases are quite like that. Interestingly, the authors wrote that cases involving domestic violence, where both parties are self-represented, are viewed as particularly well suited for the IDRT process. The IDRT rules allow the victim to introduce medical and law enforcement reports without having to call a witness to establish foundation. Additionally, the process allows the victim to avoid cross-examination by the perpetrator, and the judge is able to maintain a level of control in directing the lines of inquiry and the focus of the trial, thus mitigating the inappropriate exercise of power and control by a perpetrator during the conduct of the trial. As to the effective use of judicial time, the authors noted, in cases involving two self-represented litigants, judicial efficiency is achieved with the IDRT process. It avoids the tedium of presenting numerous non-expert witnesses to testify. There has been a marginal reduction in the amount of time the parties testify because the direct questioning by the judge keeps a focus on the legal issues to be resolved. Again, none of that would be particularly surprising to us. The article states, interesting, when considering other jurisdictions, Australia was the first jurisdiction to introduce an informal procedure sharing many of the essential elements of the IDRT. So, two questions come to mind for me when I look at what was announced on budget night by the government as to this pilot. Why didn't the government look at doing something more with the Children's Cases program, legislatively perhaps, and why do we need a tribunal rather than a judge? These are some of the questions, I think, that arise and remain to be answered. I'm supportive of trying to make changes where there's a need, and I fully acknowledge that the courts at the moment, with the pressures they are under, are not able to provide timely hearings, particularly in the sort of cases that one might expect would go to the tribunal. But while I don't want to suggest we shouldn't try this, and it might prove to be very effective, I do want to flag some issues about tribunals that might usefully be considered by those implementing the scheme. One of the benefits of having single experts providing evidence about the parties and their children is that everyone knows what their evidence is. The parties are given complete transparency and procedural fairness, and they know what has been said. They have the opportunity to challenge that evidence and to give evidence which might lead to submissions which suggest that a view proffered by an expert might subsequently need to be reviewed. Whether there will be expert evidence permitted beyond independent children's lawyers in this new tribunal remains to be seen. If members of the tribunal are to be those with particular expertise, how is transparency to be provided in relation to their views? Will non-judicial members of the tribunal come with their own biases and views, which will not be known to the participants? And will they be substituting their own views for those who would in other proceedings be called as court experts? One of the hallmarks of our present system is transparency, and part of that comes with open courts so that anyone can attend and listen to a hearing. Will there be an equally open hearing with a tribunal? I appreciate these matters might be all addressed prior to the commencement of this pilot, but I raise them because I think that a tribunal is a very different creature indeed from a judge hearing matters in a less adversarial way. A very significant difference between the Children's Cases program and the IDRT in Oregon is the establishment of a panel of decision makers with different skills. Secondly, I'm concerned that it provides one cohort of litigants with a process which is not available to others. Remember, in Oregon, there's a choice to all litigants to opt in or out of this pathway. This, it is said, will only be for self-represented parties. Thirdly, if, as I presently understand it, it's going to be confined to those who've not engaged so far in the litigation process, then at least in the short to medium term, it will not alleviate the pressures on the courts. Some capacity to transfer existing matters to the tribunal would be of assistance, though my current understanding is that that would not be available. While the tribunal is starting as a pilot, if history is any guide, then if it's successful, it is likely to become more widespread and part of the way we do family law. It may indeed constitute a very big change to our family law system, even though it relates to only a cohort of the group who needs some adjudication, that is, self-represented litigants. At this stage of my career, given that I must retire in less than 5 months, I don't have a vested interest in the outcome of the experiment, but obviously I'll be very interested to see what happens. It's useful to reflect that when the Federal Magistrates Court, of which I was the first head, commenced in 2000, our remit was to operate in a way that was to provide simpler, cheaper and quicker hearings. I think we did so for quite some time, but a number of changes, particularly in 2006, with the emphasis on mediation and mandatory pre-filing, meant that most of the cases that were capable of settlement did settle, and the cases that came to court were more serious, requiring the attention of judges and generally involving more complex facts. Given that most of the cases we see these days involve some degree of family violence and complex issues, it will be interesting to see what the work of this tribunal, as I've called it, will be. The diminution in size of the family court and the focus on appeals in the most complex cases has meant that the Federal Magistrates Court, now the Federal Circuit Court, has become overburdened, and cases can take up to 2 to 3 years to get a hearing. Undoubtedly, there is a need to do something about this. As I've said publicly many times, that delay is unacceptable. There are many alternatives, but the government has obviously decided that this one is worth a try. Considerable expenditure is being invested in this pilot. I hope it warrants the funding that might otherwise have gone to the courts. The second major announcement that was made on budget night was a review of the family law system by the Australian Law Reform Commission. This is an 18-month review, and it requires a report to be provided by December 2018, although the Commission apparently can report on particular issues before that time. The length of the review tells us that it's meant to be comprehensive. The terms of reference have not yet been released, but I'm informed by the Attorney-General that everything is on the table. I think this also has the capacity for huge change in the system. The Australian Law Reform Commission will undoubtedly look at the whole system. I think there are 4 significant features of the present system that are likely to receive attention during the course of the review, and we should all be alive to them because they're very important, I think, for the future of family law. There will be many other issues, I'm sure, that are raised. First, parenting cases. The effect of the parenting management hearings and the desirability of doing things very differently in these kind of parenting cases, at least for some cohort of litigants, will surely be part of what the ALRC will consider. The courts may take the opportunity to look at better ways of case management. The possibility of a less adversarial trial as a separate stream in the courts where both parties are self-represented remains an option. Other options must be assessed, especially as the ALRC is asked to look specifically at cases involving sexual abuse allegations and family violence. Extension of the Magellan list is an obvious topic for consideration. Secondly, I think they'll probably look at property proceedings. We have a discretionary system in Australia, but there are other options. The Hambley report looked at this in 1987 and rejected any change. But there are criticisms of the current system which will no doubt find expression in submissions to the ALRC. Whether our current system remains the best option or whether we should move to some community of property regime or at least a presumption of equality of distribution of assets of some kind will surely be raised. The third thing I think the Australian Law Reform Commission will certainly have a look at is the future structure of the courts. Do we need 2 courts? 3 if you count the Family Court of Western Australia, doing family law. And with the Family Court and the Federal Circuit Court, with concurrent jurisdiction for the most part, as well as now potentially a tribunal doing parenting cases, there will be 3 decision-making bodies operating in the space for separating parents who cannot resolve their disputes. If the parenting management hearings continue, then the system is quite fragmented. And I think there must be a serious question about whether this is the best system. I think most would agree that if we were designing the system from scratch today, we would not design one with 3 autonomous courts or a tribunal where 2 of them share jurisdiction and administration, and the operation of registries is fragmented between the 3. There are a variety of options, but I think this is an opportune time to consider how to achieve something more workable. In Western Australia, for example, although the magistrates doing family law are part of a separate magistrates court in which the chief magistrate is the principal legal officer, the legislation provides that in the case of a magistrate who is also the principal registrar or registrar of the family court, the chief judge of the family court, or his or her delegate, is the principal judicial officer. In other words, the chief judge of the family court is head of jurisdiction of both courts in relation to magistrates doing family law work. There are other options, but I think it is timely to consider a more effective system in the future for the delivery of family law. Finally, it seems to me the complexity of the structure of the Act itself has attracted criticism and will no doubt be considered. As my colleague, Justice Victoria Bennett, has written, a small but emblematic example is the fact that Part 7 of the Act starts at Section 60A. Part 8 concerns property and starts at Section 71. To non-family lawyers, those numbers may suggest there are about 11 sections which deal with children. Not so. She says, having taken the time to count them, I can tell you that Part 7 includes 238 sections and 637 subsections, organised into 14 divisions and 44 subdivisions. So I think that hopefully the Law Reform Commission will look at the structure of the Act, particularly Part 7. So we're living on the cusp of very interesting times indeed, and I will look with great interest at the recommendations of the Law Reform Commission as they come to pass. Formally reviewing the family law system after 40 years is opportune, and I think it is time to seriously look at it. After all, the genesis of the Act in 1975 was no-fault divorce. The court was initially set up to deal with that imperative. It's a long time ago now, but when we look back to that time, the Family Law Act was revolutionary because it established no-fault divorce in Australian law. This came as a huge relief for many people, particularly those who wished to avoid the cost and indignity of having to prove a matrimonial offence. Those who were around at the time, like me, will well remember the fuss. The legislation ultimately passed in the House of Representatives by one vote. Religious conservatives predicted the wholesale disintegration of the family, describing the Act as a Casanova's charter that would allow husbands to easily discard their middle-aged wives in favour of younger women. On the other side of things, soon after no-fault divorce came into effect, there were proclamations that wives were walking out of their marriages by the hundred, and that the court was biased in favour of women, and men were being economically wrecked by capricious judicial decisions in property disputes. It wasn't long before the controversies attending the Act led to the first of many parliamentary inquiries into family law in Australia, with the Joint Standing Committee on Family Law commencing its work in 1978 and tabling its report in 1980. As the Joint Standing Committee undertook its inquiry, the aforementioned concerns about no-fault divorce were certainly raised. However, the submissions also revealed something unexpected, being a growing resentment of the court's approach in custody cases. Although subsequent research demonstrated that at the time fathers were granted custody in around a third of contested cases, men's advocacy groups considered the continuing award of custody to mothers as evidence of gender bias by judges and claimed that husbands were being treated like criminals. This was the beginning of a thread that runs through the entire history of Australian family law, a push and pull between fathers and fathers' rights groups and mothers' rights groups. It also represents the beginning of entrenched misunderstandings among some members of the community about the nature of the family law system and what it aims to achieve. And you will note, as I have said, that Pauline Hanson of One Nation was recently espousing the use of a tribunal in the main part to provide for what she saw as fairer decisions for fathers. Criticism of the family court and family law more generally never really abated, though it changed shape over time. By the early 1990s, dissatisfaction mostly concerned what happens after divorce in terms of children and property. We've moved a long way from the genesis of the Act. Divorce is now an online administrative function, and the focus of the court is on contested parenting cases and property cases, not divorce. So it is time to look at the system again. At the same time, there's been a concern among mothers about ensuring the protection of children and appropriate orders for children, particularly young children, where spending equal time with the parents would demonstrably not be appropriate. In recent times, concern has arisen about how family violence is dealt with within the family courts. Will a tribunal make a difference to these things? Will one or other of the groups find it less appealing or more attractive? It remains to be seen, I think, how this will play out. In terms of those actively lobbying for legislative change, advocates on both sides at times descend to hyperbole and rush to judgment. Let me give two examples, although there are many, and you'll be familiar with them. First is the shibboleth that we still see, that men kill their children or commit suicide as a result of unfair decisions made by the courts. And this is still something that you hear One Nation talking about. Interestingly, most of the cases that I've seen where there have been deaths did not involve situations where a parent had been denied contact or was unable to enforce orders. They are cases where there are orders in place and where often orders are made by consent. There may or may not be proceedings on foot, but if they are, these are temporal, not causative. Fortunately, there's now a substantial body of research into the phenomenon of familicide, but concrete causative factors have not been identified. A 10-year study of filicide in Victoria conducted by Professor Thea Brown and colleagues at Monash University showed that the perpetrators experienced multiple stresses, especially mental illnesses and parental separation, but also domestic violence, substance abuse and child abuse. Further research is required to test these findings and to explore the relationship between the stress factors. A 2006 article by Carolyn Johnson in the Family Court Review entitled Familicide and Family Law, a study of filicide-suicide following separation, reported the findings of a study examining 7 Western Australian cases of family homicide followed by suicide, where custody or access issues, as the researchers called them, were identified as being an issue. This is one of the few in-depth studies I'm aware of that looks specifically at the intersection between family homicide and family law disputes. A section of the study is entitled Misconceptions, and the two key ones emerge. The first is that familicide is caused by a legal dispute. Johnson's study did not support this. In fact, not one of the survivors she interviewed perceived there had been a dispute with the other parent as to custody or access, and only one family out of the 7 studied had proceedings before a family court. The second misconception was that fathers are denied contact with their children, and this results in them taking their children's lives in their own. In all of the cases reviewed by Johnson, the father was having contact with the children. On the other side of the gender divide is the shibboleth that judges knowingly or negligently place children in harm's way by allowing contact with dangerous parents. The Darcy Freeman case provides a germane example, and you'll all be familiar with that case. The case involved a separation of many years, three children living with both parents for a number of years. A dispute over how many nights the children would stay with the father was resolved by consent before the hearing concluded, and the judge didn't have to make a decision. The mother agreed to the children spending the following weekend with the father, and on the morning of 29 January 2009, when he was driving all 3 children back to Melbourne to be returned to the mother, the father stopped his vehicle in the emergency lane of the Westgate Bridge and in full view of horrified morning commuters threw Darcy from the bridge. The father's actions were unbelievable, outrageous. The very nature of them, one might think, would indicate they were totally unexpected. And yet there was a huge outpouring of anger towards the courts for failing to protect Darcy, and I remember this very well at the time. Women's groups organised rallies in all capital cities in order to protest courts allowing dangerous parents to see their children. The people attending the rallies were encouraged to wear red scarves to signify the blood of Australian children being shed by family court orders. Arthur Freeman was convicted of Darcy's murder. Ultimately, the coronial inquest found that the father's actions in this case and Darcy's death could not have been predicted with any certainty. At this time, the coroner said, as he had said at the inquest into Luke Batty's death at the hands of his father, there is no validated risk assessment tool that can accurately predict whether a parent is likely to commit filicide. That remains true, but adequate resourcing of courts does assist in early identification of risk factors. In respect of the issue of family violence, there were some additional welcome announcements made on budget night. One of these is the funding of 17 new positions for family consultants across the 3 courts. This is a welcome initiative which will enable the courts to provide some case management where they have not been able to do so in the past, particularly in relation to the administration of risk assessment reviews when proceedings are first commenced. And as I've been asking over a number of months for an initiative like this, I was particularly pleased to see that someone had actually taken notice of it. No sooner, however, does one issue die down than another arises in family law, as you would know. Not long after my appointment in 2004, I was confronted with huge publicity from a quarterly review piece written by the historian John Hurst about the family court entitled Kangaroo Court. This was an assertion that fathers were unfairly treated by the court and got a lot of publicity. I have 5 months left as Chief Justice, but I doubt I've seen the last of unwarranted criticisms. At the last Senate estimates hearing, we were asked about allegations that judges altered transcript in hearings in a material way. Apart from the impossibility of doing so, as we don't have access to the written transcript, and Auscript is an independent provider who controls the process, the allegation is nothing short of appalling. It is in fact an allegation made with no specificity, which amounts to a judge perverting the course of justice. If there was any evidence of such a thing, it would warrant serious consideration for removal of the judge by both houses of Parliament. And yet the allegations are raised in the Parliament and get into Hansard without regard for the potential damage to the public perception of the courts. As a result of things like this, I see it as part of my role to meet with various senators and explain and discuss some of these things. And I do that. So far this year, I've met with Senators Hinch, Xenophon and Hanson. I can say that I always get a good hearing and my message is generally understood and that meetings are helpful. Legislation to prohibit cross-examination by self-represented alleged perpetrators of alleged victims will also be the subject of some legislation, again announced on budget night. On its face, this is a good initiative, but without the capacity to provide legal aid, or at least legal assistance of some kind, where evidence does need to be challenged, it's going to be interesting to see whether this is an impediment to courts being able to make findings. It may, of course, turn out that these kind of matters will be appropriate for and perhaps better dealt with by the tribunal. But if one party at least is represented, that doesn't seem to be possible, and the problem will still arise for the courts about how disputed facts, which may traverse many areas including property settlement and child support, are to be resolved if there is some sort of a blanket denial on the ability to cross-examine operating. Finally, the other good news from budget night was, of course, the provision of funding of $3.4 million for the expansion of the domestic violence unit pilot to establish up to 6 new domestic violence units delivering an integrated specialist service and social support to women experiencing or at risk of family violence. At the launch of this initiative at the Parramatta Court this week, the Attorney-General observed that 23 family advocacy and support services were being established by legal aid commissions across Australia, 14 of which are already operating. As the Attorney noted, the new service integrates duty lawyers with specialist family violence workers to help families navigate between the federal and state court systems and also connect people with the risk assessment, safety planning and other services they might need. This is clearly a very welcome and positive initiative that will make a considerable difference to those who've been subjected to family violence. In Parramatta, for example, in the court, a safe room's been set aside for women and their children when these services are being accessed. The court has also had long had a family violence plan in operation dealing with protection of those who come to court where allegations of family violence have been raised. So looking back at what happened on budget night, as I said before, I think this is somewhat of a watershed. I think we can safely say that the government is taking family law seriously, and whilst there are issues to be worked through with legislative change and some of the proposals, there is clearly an interest by government at last and a wish to support the courts and come to them. I hope we are entering an era of interest and concern about family law. Finally, I wanted to comment on Section 121 and social media. In recent times, we at the Court have noticed increasing numbers of people putting significant amounts of information about their family law matters onto social media and on other online fora. Many such posts are in breach of Section 121 of the Family Law Act, which is obviously a concern, and people include photographs and the names of their children. Section 121, as you know, prohibits the publication or dissemination of any interest that would identify participants in proceedings under the Family Law Act. It's aimed at ensuring that people don't feel discouraged from coming to court for fear of having their private life made public. More crucially, the law is designed to ensure that children are not held up to ridicule, curiosity or notoriety. In terms of judgment publication, when I became Chief Justice, I instituted a policy that all family court judgments would be published, which had not previously been the case, and made publicly available via Ostly in order to facilitate transparency of the work of the court, and I think that's been a very important initiative. At the same time, we had to work out how to maintain anonymity, so the parties are allocated pseudonyms and the judgments are published under those pseudonyms. All information that could be used to identify the parties is painstakingly removed by our judgments publication team. So it comes not without a cost, but in my view, it's a really important initiative. We're able to publish the judgments and, at least for the most part, not identify the parties. Section 121, of course, was introduced at a time when media meant print media and television. Those outlets are not a problem for the most part, but the unregulated online fora and social media have changed this dynamic, and the usefulness of Section 121 may need some reconsideration. We can certainly see the use of social media when it replaces traditional forms of media can be problematic. The internet is changing our culture, and our legal culture will likely be increasingly affected by it. I think it's important for those involved in proceedings to understand that the best advice comes from lawyers, not online forums. And we're starting to see a cohort of people who take their advice, bad advice usually, from online forums. I'd started to think about whether we really needed Section 121 in view of social media, and that perhaps there should be some significant amendment. That was until I saw the recent publicity, that you may also have seen, given to the Anthony Bell and Kelly Landry case in the Magistrates Court in Sydney over an AVO. The notoriety that received and the way in which it was reported confirms my long-held view that protecting children from having their parents' disputes the subject of public scrutiny is still very worthwhile. And I support the continuance of Section 121. I think that's a very good example of why we should have it. I focused on the major areas of our work, but there are other interesting areas in which, of course, we exercise jurisdiction. I don't have time to discuss them, and I simply note them. But they also, or some of them at least, might be areas for the ALRC to look at. Surrogacy, gender dysphoria cases, life support or medical treatment for children when parents and hospitals are in conflict, international child abduction cases under the Hague Abduction Convention and relocation cases, particularly international ones, property powers involving third parties, de facto property disputes and binding financial agreements. And I note, as we no doubt all do with interest, that I can't remember the name of the case offhand, but the High Court's given special leave to look at the question of duress in relation to binding financial agreements, and that's going to be a very interesting decision, particularly as Justice Edelman was one of the two judges who gave special leave, and as an academic he's written extensively on the topic of duress. Family law is perpetually unpopular and an undervalued area of law, and yet it's absolutely essential, dealing as it does with fundamental human relationships. Australia has a continuing history of trying to reconcile this paradox. While the Act's convolutedness is a well-known problem, and the almost constant review of the Act has been a source of annoyance to many, these challenges seem to reflect the complexity of what we are dealing with when we make and apply family law. When you think about the changes society's seen in the last 40 years, it hardly seems surprising that social legislation like the Family Law Act will be trying to keep pace with the times. So now another year, another review, and likely further amendments. What it will look like and where it will lead, we have to wait and see. We haven't yet crafted a perfect family law system, and I wonder if we ever could, but our legislators will keep on trying, and we should encourage them to ensure that we have a properly resourced system which the community well and truly deserves. And I'm not sure that we're getting quite that at the moment, and we should make that point, I think, to the ALRC when they review the system. Personally, I feel privileged to have been Chief Justice of the Court and to have had the opportunity to play a part in judging, administering, occasionally shaping and explaining and defending the family law system. Thank you.